AHLA is pleased to present this special series highlighting the top 10 health law issues of 2024, where we bring together thought leaders from across the health law field to discuss the major trends and developments of the year. Support for AHLA in this series is provided by PYA, which helps clients find value in the complex challenges related to mergers and acquisitions, clinical integrations, regulatory compliance, business valuations and fair market value assessments, and tax and assurance. For more information, visit pyapc.com.
Hello, everyone, and welcome to the third episode of the AHLA Top 10 series. This particular episode is going to be focused on antitrust trends and a forecast for the healthcare industry. I am Michael Ramey with PYA. I'm a principal in our healthcare consulting group, and I lead our strategic and transaction advisory services. The areas of focus for my practice are transaction advisory services, strategic planning, and valuation, mainly to hospitals, health systems, private equity, investors within healthcare, physician practices, and lead a team that predominantly works through due diligence matters, facilitation of transactions, and post-merger integration, as well as strategic planning initiatives. I'm joined today by Rosa Morales, who is the author of this article. She's with Kroll & Mooring, and I will turn it over to her to introduce herself.
Thank you, Michael, and thank you for having me on your podcast. My name is Rosa Morales, and I am a counsel in Kroll & Mooring's Antitrust Group based out of New York City. I counsel and represent clients on a range of antitrust and competition issues, including in litigation, antitrust litigation, as well as in government challenges to transactions, multi-district litigation, and class actions. I also specialize in various sectors, particularly on healthcare and pharma, telecoms and media, and the financial sectors. I'm happy to be here today.
Great. Thanks for joining us, Rosa. So expanding upon the article a little bit, there were several merger guideline changes proposed by the DOJ or the FTC in 2023. Can you help us understand, as we sit here today, kind of what's still proposed versus what's finalized, what's being implemented, just a little bit clearer picture of the current landscape?
So I believe it was shortly after we published that article, the FTC and the DOJ jointly released the final merger guidelines on December 18, 2023. The new guidelines reflect changes from public comments on the draft version that was released in July 2023, but the main principles under the new guidelines remain the same. Broadly speaking, the new guidelines reflect what we've seen as an aggressive approach to merger enforcement under the Biden administration. And generally, they establish lower thresholds and presumptions that make it easier for the agencies to challenge mergers that they have viewed problematic in the past and have had a difficult time successfully challenging. For example, the new guidelines set out new market share and lower market concentration levels to identify presumptively unlawful horizontal mergers. They also establish presumptions that can be rebutted with evidence to show that a merger would not be anti-competitive. In that case, there's a bit of a shift a shift in burden to the transacting parties to show that the merger is not anti-competitive. And notably, the new guidance also includes language that update theories of harm that are designed to address in more detail platform markets, labor markets, serial acquisitions, and minority investments that tend to be associated with private equity firms. Now, the guidelines are, as you know, industry agnostic, but they do seem particularly primed or amenable to support and legitimize the agency's historical scrutiny of healthcare mergers and acquisitions, which may not be any accident, as you know. The agencies have long viewed consolidation in the healthcare industry as leading to increased healthcare costs for consumers. And that has been a priority under the current administration as well as for the agencies in recent years. Now, the framework appears to target areas where the agencies have faced enforcement challenges, in particular in traditional and non-traditional vertical or cross merger transactions that are prevalent in healthcare. And where the agencies have experienced setbacks in litigation until very recently, such as in the FTC's recent appellate win in the before the Fifth Circuit in the Illumina Grail case, which ultimately led to that that merger not proceeding. Now, while the guidelines reflect an aggressive enforcement for mergers, it is a little too early to tell how the agencies will proceed. But they, on their face, appear to add risk for deals that are prevalent in the healthcare industry. But for parties that have been interacting with the agencies in recent years, some of these principles have already been playing out, so it may appear as if it's business as usual. But it is what we can foresee is at least in the near future is that merger enforcement will continue to be aggressive, at least under this administration.
It's interesting as we go into a election year. We are now, I guess, technically in an election year. How that might impact if there's any potential administration or legislative changes as a result of those elections. Any thoughts on how that could impact implementation in 2024 and potentially beyond?
So as you know, the new guidelines are non-binding. The merger guidelines are non-binding. They are not law. They provide key insights into how the agencies will evaluate transactions for potential antitrust concerns. And as mentioned, the new guidelines are closely aligned with the Biden administration's policy for more aggressive enforcement of the antitrust laws across the board. And those principles were articulated in the president's July 2021 executive order on competition. But as you mentioned, we have been in an election year probably for the past 3 years. So that means that given the leading candidates in at this early stage in the presidential election year with different views on competition enforcement, this may all change if the White House changes hands in November. So what we might see is there's a pronouncement of a new approach that has already been playing out in recent years, but that approach may change if there is a change in the White House. And beyond that, beyond the impact that on enforcement that a change in administration may have, the guidelines have also historically served as persuasive authority for federal courts in antitrust litigation. And even though it is a little too early to tell what the courts will do, there is some critics have observed that the courts may not be particularly amenable to giving the guidelines the same type of weight that they have in the past, particularly given the changes in the judiciary in the past decades. So it's anyone's guess what the long-lasting impact of the new guidelines will be, but for the time being, I think that we can count on the agencies continuing to pursue their aggressive enforcement in merger review.
Great. And Rosa, you mentioned earlier that the agencies are also focused on pursuing less traditional theories of harm. Can you maybe expand upon that just a little bit as to what additional they may be looking into?
Sure. So I mentioned that the guidelines provide new frameworks that assess the competitive effects of mergers. And these new frameworks reject flexible analytical approaches that were allowed under the or permitted under the prior guidance in favor of more rigid, rebuttable presumptions of harm to assess the competitive effects of deals based on lower thresholds that allow the agencies to more easily challenge less traditional deals. These include vertical and cross-market transactions that historically have been difficult to challenge under the old frameworks. For example, the new guidelines will presume competitive harm in horizontal transactions when the combined market share of the transacting parties is 30% or greater, even if one of the parties' shares is minimal on its own. In the vertical merger context, the new guidelines presume foreclosure harm if one party holds a 50% share in any upstream or downstream market. And finally, the guidelines apply heightened scrutiny on transactions that would entrench an existing dominant position of one of the parties or extend dominance into another, which is defined under the new guidelines as 10% or higher market share based on European standards of dominance. The transacting parties can rebut this with evidence that the merger is unlikely to negatively impact competition. Now, as a practical matter, dynamic and volatile industries like healthcare, where transactions between competitors or transactions that may lead to further consolidation of integrated health systems, for example, may face more regulatory hurdles to clear. The new guidelines will make this will add the possibility of increased transaction costs and potentially prolong regulatory review. Another aspect of the guidelines that is especially pertinent to the healthcare industry is the agency's skeptical view of consolidation and serial transactions that are increasingly common in the healthcare industry. For example, acquisitions of physician practices by private equity firms. The agencies have been, and in the guidelines have made clear that they will continue to closely scrutinize transactions that focus on future consolidation activity or serial acquisitions, and are assessing the aggregate competitive effects of a series of acquisitions as opposed to assessing the competitive effects of a single transaction that may, in the end, be on its own competitively neutral. We saw this play out early on in the FTC's challenge to an acquisition by a private equity fund, Welsh Carson, and its investment company in US Anesthesia Partners in the Southern District of Texas. I believe that was in September of last year. The FTC in that case alleged that Welsh Carson and USAP, or the US Anesthesia Partners, engaged in anti-competitive conduct to monopolize the anesthesiology markets through a series of roll-up acquisitions that USAP made over several years, as well as looking at various price-setting agreements that it entered into with competitors and market allocation agreements with competitors that were designed, in the FTC's view, to monopolize the anesthesiology market. So the FTC there focused on the roll-up strategy that is sort of implied in the, if not flatly, just explicitly laid out in the new guidelines as part of a monopolistic scheme that would not really pan out well under older, more traditional theories. We'll see if the courts credit these new theories, but the implications for healthcare companies and larger physician groups that adopt serial acquisitions as a business strategy for growth will have to contend with these new realities.
That's really helpful, Rosa. Thank you. I've also seen an increased focus and scrutiny on the impacts on labor markets in evaluating transactions. Can you maybe comment a little bit about what you're seeing in that realm?
So, we have seen in recent years that the agencies have been intensely focused on identifying the competitive effects of mergers and acquisitions in labor markets. And we will continue to see that. In fact, where there was doubt about whether the antitrust laws, or particularly as it relates to mergers, encompassed or addressed effects in labor markets, the new guidelines have made that very clear, that the agencies will continue their aggressive enforcement in labor markets, or looking for labor market impacts. They will, and I think you've seen this play out, Michael, in recent years, where the agencies have looked for evidence of collusion, particularly between competitors for labor, even where they don't compete for services or products. They have been looking for evidence that competitors for labor have agreed not to compete for workers, as well as entered into agreements to fix wages. And where the FTC has identified evidence of such conduct, it has referred these instances to the DOJ, that has in some instances pursued, launched criminal investigations and issued indictments for individuals and companies that have been identified as having engaged in this conduct. So I think that the explicit inclusion of labor as an area of focus in the demerger guidelines signals to parties that this is not going to go away, that the agencies will continue to look for labor effects, and that the antitrust laws apply to labor markets equally if there was any doubt in the past.
Thank you for that insight. One more question, switching gears to the how. There's also changes to the Hart-Scott-Rodino Act filing requirements, which make that more onerous in terms of the volume of information that must be included within those filings. Rosa, what recommendations do you have for transaction counsel to be able to manage those new requirements?
So, as you suggested, the proposed changes to the HSR forms and the enhanced filing requirements are going to give the agencies more tools to develop the theories of harm that we just discussed under the new guidelines, and more fodder to pursue investigations where they identify competitive concerns. But as a practical matter, even in the absence of that, these new requirements are going to increase the burden on transacting parties in HR filings. In fact, just recently, the FTC Commissioner, Rebecca Slaughter, warned that the HSR changes are going to have a much more material effect than the guidelines on how the FTC actually executes its responsibilities to review transactions. So we are heeding that warning. So your question, how should transaction counsel manage the new requirements that are sure to come, because these have not been finalized yet, but we expect them imminently. The proposed changes are going to dramatically increase upfront disclosures in HSR notifications, and will require parties to produce a cross-section of strategic business documents, in addition to documents related to the transaction itself. These documents are going to include drafts of transaction-related documents, in addition to the final documents that we've seen being required in the past. Narrative descriptions of products and representations regarding planned products that may be potentially competitive with those of other merging parties, and information and data on employee types. And I think that this is sort of in line with the agency's focus on the potential impact in labor markets. So they're going to require more documentation regarding how employees might be affected. So counsel should really I think that what this means is that council should really start early. So when they are contemplating a transaction, because of the heightened scrutiny on growth strategies that involve serial acquisitions and the other issues that the agencies are focused on, you want to make sure that you know what's in your documents. You want to know that your documents are not going to create bigger problems down the line beyond just trying to get the deals cleared. So it is wise to engage antitrust counsel early on. It is wise to implement compliance programs that, especially if your deal is years down the line, it is wise to implement compliance programs to train your employees and training programs to train your employees about how to create documents that don't raise any competitive concerns in connection with merger reviews. So it'll be really important for merging parties to fully understand the internal documents before signing deal documents, and to develop a strategy for how to engage regulators on potential issues under the guidelines. That means that they should also be armed with a potential litigation strategy early in the review process, and also prepared to consider any potential remedies or modifications to deals in order to clear them, or to resolve competitive concerns, as well as to improve the litigation odds should the case be challenged in court down the line.
Great. Well, Rosa, thank you for your time today. This has been really informative. I know we've just started scratching the surface of everything we could talk about here. We didn't even get into the matters as to the why associated with some of these matters, and including the enforcement associated with providers compared to maybe other segments of healthcare. But we'll reserve that for maybe a future podcast. But appreciate you joining us today. Appreciate the article. Would encourage everyone to go download that for additional information and contact Rosa if there's any follow-up questions. With that, we'll conclude our podcast. Have a good day.
Have a great day. Thank you so much for having me.